Hey guys, this is an introductory video to shareholders agreement. What is a shareholders agreement? A shareholders agreement is a contract between the shareholders of a company which govern their relationship with each of the shareholders and the company. It is an additional form of protection which supports the articles of association of the company because it gives the shareholders greater say over how the company is run. Is it compulsory to have a shareholders agreement? No. Why? Because if there's no shareholders agreement, then you can rely on the constitution of the company, the articles of association, which set out the rights of the shareholders. But the problem with the constitution, the standard constitution, is that there are a lot of issues that are not addressed in there, which cannot protect the rights of minority shareholders, or even matters like dividends or reserve matters, information rights. These things are not set out in the Constitution or the Articles of Association. Since all parties to a contract are bound by the contract, therefore all shareholders who sign the shareholders agreement are bound by the shareholders agreement. But what if one or two shareholders refuse to sign the shareholders agreement? Well, then his rights will be governed under the Constitution or Articles of Association. Now, what are the benefits of a shareholders agreement? Firstly, you can include reserve matters. Reserve matters are things that minority shareholders, those holding a small percentage, 20%, 30%, 10%, they require the unanimous approval. That means everybody has to agree before an important company decision takes place. For example, you can state that you can have a list of reserve matters where, number one, if you want to change the name of the company, all shareholders must agree. If you want to buy equipment more than $300,000, all have to agree. If you want to increase the director's salary, okay, all shareholders agree. This is particularly effective for protection of minority shareholders, because if there's no shareholders agreement, then the major shareholder can simply just pass resolutions to pay huge amounts of directors' fees to the directors, who are probably the majority shareholders. And then there's very little money left after the profits to dividend out to the minority. So this is called minority oppression. Other reserve matters could include investing in other companies, issuing of dividends, the amount of dividends, the frequency of dividends. They could also include the incorporation of subsidiaries, going to different businesses. Such things, if set out in the shareholders agreement, will require either a percentage, like let's say 80% have to agree, or all have to agree. So if one or two of the minority shareholders disagree with a proposed transaction stated out in the reserve matters, then the company cannot go about doing it. Another benefit of a shareholders agreement is that small groups of shareholders can regulate the appointment and removal of directors by allowing a small group of shareholders, or one shareholder or an investor, to appoint one or more directors. For example, if there are 10 shareholders in the company, okay, and 4 of the shareholders hold 30% of the total shares, you can state in the shareholders agreement that this group is allowed to appoint up to 2 directors to the board, and the majority shareholders holding 60 are entitled to appoint up to 3 directors onto the board. The shareholders agreement is also useful in the sense that you can set out the responsibilities of each party. For example, shareholder A is in charge of day-to-day operations, shareholder B is in charge of marketing and finance, shareholder C is in charge of business development, blah 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 blah. Another matter that is not found in the Constitution, information rights. You can put a clause in a shareholders agreement that the shareholders are entitled to monthly, quarterly, semi-annual, annual financial statements. They have the right to inspect the company's books at any time. The shareholders agreement can also contain an anti-dilution clause which may not be found in a standard constitution. This means that if the company raises capital, like issues new shares to shareholders or external investors, the existing investors have a right to participate pari passu. That means in proportion to their shareholdings, so their shareholdings do not get diluted. Shareholders agreements can also provide for deadlock. What is deadlock? Deadlock arises where some shareholders want to do something, the other shareholders oppose it. There are many different ways to resolve deadlocks, one of which would be call options, put options. You can also have what is called Russian roulette. You can Google it. Or you can have one where if there's a deadlock, then each of the shareholders have to make a bid for the other shareholders' shares. The highest bidder gets to buy out all the other shareholders. Next benefit of a shareholders agreement that you cannot find in the Constitution: dividends. It's very important to have a dividend policy. How often are dividends paid? Semi-annually, annually, at least 50% of dividends are paid out, or is it at least 80% of dividends are paid out? It's very important. Speaking of dividends, under the clause on directors, it's also important to put the agreed amount of directors' fees paid to the directors. It's also important to include that any increase in the remuneration of directors have to be by unanimous consent to address the issue I talked about earlier, minority oppression, where the majority shareholders can just increase directors' fees and reduce dividends. Another important thing to include in a shareholders agreement that cannot be found in a constitution is a non-competition clause. You do not want shareholders in your company to be setting up competing business and siphoning off customers, suppliers, and leads and contacts or whatever from the company that they are in. Next, drag along rights. If the majority shareholder wishes to sell their shares, the minority shareholders cannot refuse and must sell. What this means is that, for example, if I hold 70% of the shares and somebody offers to buy my 70% at $1 million, so if there's a drag along clause, that means I can exercise my right to drag along the 30%, force them to sell their shares to the new buyer, because most people don't want to buy 70% of a company. There's also this thing called tag-along rights, which are for the benefit of minority shareholders. Essentially, when the majority shareholders are selling their shares or part of their shares, the minority shareholders are allowed to tag along to the majority shareholder. For example, I hold 70% of the shares in a company. I want to sell half of it, which is 35%, to a buyer. So the minority shareholders have a right to tag along to me by selling half of their shares also to this new buyer. So thanks for watching this introductory video on shareholders agreements. Stay tuned for the next few videos.